Hi everyone. So I'm just going to do a sound check and make sure you can hear me okay. Just let me know if you can't. Brilliant. Okay, so the other day when I was doing my sessions with my small group, there appeared to be some audio issues and I was glitching, so I moved to another location. If that happens tonight, just let me know and I can always switch places. So now that you've had your LGS on costs by David Leung, this really is your last substantive lecture. And we're going to cover a huge topic tonight of appeals. Obviously, this is very relevant for your written exam because in the written exam, you will be asked to draft a memorandum of advice. You will be a trainee solicitor drafting the memo to a senior partner, and you'll be advising on grounds of appeal. And those grounds of appeal could be against conviction, sentence, costs, all of them, some of them. Okay. Um, so, what we're going to look at tonight is grounds and procedure for the defendant to appeal his conviction and sentence, as well as a special procedure in the magistrate's court where he can review his decision. We're going to look at how those procedures are different, where he's appealing from the magistrate's court versus the DC or CFI. We'll look at the prosecution's powers to appeal and review as well. And we'll focus on those procedures. We will probably not spend time on lodging an appeal to the CFA, but I've included that information for your reference. We have never had an exam fact pattern, nor do I think that we will, which involves an appeal to the CFA. Okay, and then also it's important that you know how to appeal against costs as well. Okay, so a bit of required reading. Make sure you take a look at these practice directions because they really help you to understand the procedures that are involved in an appeal. But as a general principle, we have to find a statutory basis to appeal because there is no common law right of appeal. And generally, if we are appealing questions of fact or matters that come within a judge's discretion, in other words, sentencing, a sentencing judge has a very wide discretion, then that is going to make our appeal much more difficult because a court on appeal has only a limited power to interfere with findings of facts or matters within a judge's discretion. From the MC, we are appealing to a single judge in the CFI, and we don't need leave to appeal. There is the possibility of an appeal to the CFA, but the CFA is not a second court of appeal. There's a very high threshold to be met in order for leave to be granted to appeal to the CFA. But within the magistrates, we're going to look at a special procedure in section 104, which allows for a magistrate to review his own decision. And that's where the decision is reconsidered, but within the same level of court. It's not an appeal to a higher court. With an appeal, we're always looking at having a higher court take another look at the lower court's decision. From the district court, CFI, we are appealing to the Court of Appeal, and whether or not you need leave depends on what it is that you're appealing. We'll look at that later. Okay, and then from the DC CFI to the Court of Appeal, generally, if it's an application for leave, it's heard by a single judge. But where you actually hear the appeal itself, it would be before the three judges. From a defendant, then, you can see that he can appeal from the magistrate's court. There's two avenues that we will look at, Section 105 or 113. Basically, because of Article 11 of the Bill of Rights, a defendant has the right to appeal his conviction to a higher court. So that's why we see these statutory provisions. The appeal to the CFI, and then after that, there is the possibility of a further appeal to the CFA, provided that leave is given. And then you can see the appeals mechanisms as well. The reason why, if a defendant is convicted in the magistrate's court, he can apply to the CFI, appeal to the CFI, and then he has to go directly to the CFA. He can't go additionally to the Court of Appeal, is you could see that that would give a defendant convicted in the magistrate's court an additional level of appeal, which would be unfair compared to those defendants convicted in the CFI or district court. So just to help you, I've summarized the different options of what the prosecution and defense can do in terms of appeal or review. But let's look first at appeals by way of case stated. So you need to read the provisions of section 105 to 112 of the Magistrate's Ordinance. Either the prosecution or defense can use these provisions to appeal by way of case stated. But in practice, it is always done by the prosecution. The reason is that these provisions are more time consuming. There are more stages that you need to go through in order to be appealed. What can be appealed is more limited in scope. You can only appeal by way of case stated on a question of law or that the court has acted in excess of its jurisdiction, but you can't appeal findings of fact. And the defendant won't usually use these provisions to appeal his sentence because it's much easier for him to do so under section 113. So 105 appeal is more cumbersome, more hoops to jump through, more costly, takes more time. So in practice, usually relied on by the prosecution rather than the defense. And this type of an appeal is an appeal stricto sensu. We'll talk about in a bit about the different types of appeal, but basically what this means is you have to be able to identify an error of law in order to successfully appeal. Just a reminder, if you're joining, can you please mute yourself? Because I can hear someone who's just joined and they are not muted. So for this type of appeal, the judge is restricted to just considering the grounds that are set out in the case stated. So he can't consider any additional grounds other than what is laid out in the case stated. And the Court of Final Appeal in this case of Hoi Lai Ki has clarified that an appeal by way of case stated under 105 is an appeal stricto sensu. In other words, you have to identify an error of law by the magistrate, and he can only consider the grounds of the appeal. It's not a rehearing type of appeal. You have to apply within 14 clear days of the magistrate's decision. And by the reference to clear day, it basically means that if the magistrate has convicted the defendant today, you don't count today as day one. You start counting on the following day, which would be day one. So time starts to run the day after the magistrate's decision. And you can't get an extension of time. So if you miss the deadline to appeal within 14 clear days, then the only option for the defendant would be to look for another avenue of appeal, and that would be 113 of the Magistrate's Ordinance. You have to use Form 95 to appeal, and basically what the appellant has to do is draw up first a draft case, going through the findings of facts that they wish to challenge, what the submissions were at the trial, what the decision was on those facts and issues, and then particular questions for the judge in the CFI to answer. And you don't need leave. You never need leave to appeal a magistrate's decision, whether it's under 105 or under 113. 113 is very strangely titled the alternative procedure, but actually in practice, it is the most common way for a defendant to appeal a magistrate's decision. Only the defendant can appeal under subsections 1 or subsections 2 of 113. And I said to the full-time students when I gave this lecture last week, if you pull up these relevant provisions as we're going through, I think it's much more easy for you to understand what I'm actually talking about. So let me just stop screen sharing this for a minute. Hold on a second. And what I will do is let me actually screen share the magistrate's ordinance. And let's look in particular at section 113. Now, remember, in your exam, you could have a defendant who's convicted in the MCDC or CFI. So you need to figure out where he's been convicted. And then, depending on where he's appealing to, that's going to affect your advice on the procedure for appeal. Okay, so let's go back now and let me share this screen with you of the magistrate's ordinance. Okay, so hopefully you can see now, this is section 113. So you can see subsection 1, this is the right of any person aggrieved by any conviction, order, or determination of a magistrate who did not plead guilty or admit the truth of the information or complaint. They can appeal against the conviction, order, or determination. Okay? So only the defense can rely on subsection 1 because only the defendant would have been someone who did not plead guilty or admit the truth of the information. And subsection 1 also means that if the defendant pleaded guilty, he cannot appeal his conviction. The only option is under subsection 2. If he pleaded guilty, then he can appeal his sentence unless it's fixed by law. Okay? And in the magistrate's court, really, the only sentences that are fixed by law are for very minor offenses, like, say, road traffic offenses have a lot of fixed penalties for speeding or parking in an undesignated place. But the prosecution cannot rely on subsections 1 or 2 of section 113. So let me just stop sharing for a minute. And here, and let's go back to our slides. Okay, so an appeal under section 113 is an appeal by way of rehearing, either with or without evidence. What that means is that fresh evidence can be introduced on appeal. But it's not a complete rehearing. It's not a retrial. So basically, all that the judge in the CFI is doing is looking at the magistrate's reasons for verdict, statement of findings, the transcript of what happened at the trial, but not the full transcript, just limited sections of the transcript that have been identified relating to the grounds of appeal. And there's no indication in sections 105 or 113 what the grounds of appeal are, because you can appeal a wide variety of things, like under 113, his conviction, order, or determination. Whoever's joined, please mute yourself. It's really annoying and distracting. But you can appeal on the same basis that we will be talking about as when we're appealing to the CA. So conviction is unsafe or unsatisfactory, wrong decision in law, or a material irregularity for conviction, and then those grounds of appeal for sentence. For the prosecution, on the other hand, they can rely on subsection 3 of 113, provided that what they are appealing is not relating to or in connection with an offense. So let's go back and let's look at that particular provision. So if we go back to subsection 3, you see that after the hearing, blah, 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 which the magistrate has power to determine in a summary way, other than a determination or proceeding relating to or in connection with an offense, either party may appeal from such order or determination. Okay? So what does this language, other than a determination or proceeding relating to or in connection with an offense, means? Basically means that the defendant cannot use it to appeal his conviction, nor can the prosecution use it to appeal the defendant's acquittal. Okay, they could use it, for example, to appeal a costs order that the magistrate had made. They could use it to appeal a decision to grant bail pending appeal, because a magistrate can do that. So the prosecution could appeal under subsection 3, but not if it relates to the defendant's acquittal or conviction. And an appellant has to decide which avenue of appeal he's going to proceed under, either 105 or 113. He can't use both at the same time. It's one or the other. And from the defense perspective, it's much easier and cheaper for him to go by 113. And also, the grounds of appeal are wider because remember, 105 is just restricted to errors of law. So under 113, you have to appeal within 14 days of conviction or sentence, and there is no reference to clear days, which means that if the defendant is convicted today, today would be day one, right? And we know that because the magistrate's ordinance doesn't mention clear days. You can get an extension of time, though, if to appeal if you can show good cause. Now, 105, there was the reference to clear days. So you start counting on the next day, but no extension of time is possible. 113, no clear days. So you start counting on the day of the decision, but you can get an extension of time. So you just need to remember the differences between those two sections because in the exam, you might be, well, you will be asked to give the deadline, the last date to appeal. So you have to be able to calculate that in the exam. And it will tell you what date he was convicted on or what date he was sentenced on. And then you have to advise what's the deadline to appeal. So I always tell my students, make sure that you take a printed copy of a calendar for probably November and December of this year, as well as January next year, just to cover yourself, depending on what the date of conviction and sentence is, okay? Because you're going to need to know when is the last day. And we'll see that there are complications if the last day ends on a public holiday. So how do you appeal? Under 113, if it's conviction, Form 101, sentence 102, the magistrate then prepares a statement of findings within 15 days with his reasons for verdict, and an appeals bundle gets prepared for the judge in the CFI, and that contains the reasons for verdict, reasons for sentence, the trial extracts of the trial transcript, etc. Now, you always file initial grounds first because the deadline is quite tight, only 14 days. And then after that, once you have obtained the transcript, then you can perfect your grounds before the hearing as well. And an appeal under 113 is a rehearing. Now, Section 118 refers to depositions of witnesses being placed before the judge in the CFI. What we generally mean by a deposition is a statement given under oath by a witness when they are cross-examined and give evidence in chief, and then a formal deposition is drawn up of what they have said. That's what we generally mean by a deposition. But actually, although 118 refers to depositions, that's not actually what takes place in practice. What takes place in practice is that the CFI judge gets an extract of the trial transcript that's prepared by the registrar, depending on what the grounds of appeal are. And the CFI will never hear testimony from witnesses, right? So for that reason, they are very reluctant to interfere with matters that go to the credibility of a witness because they have no opportunity in the CFI to observe the demeanor of the witness. Now, this is an important case, Hoi Lai Ki, last year in the CFI. Prior to this case, it used to be thought that whether you were proceeding under 105 or 113 of the magistrate's ordinance, you had to show that the magistrate's decision was plainly wrong or illogical in order for the CFI judge to overturn that decision. But Hoi Lai Ki clarified that section for an appeal by way of a rehearing under section 113, you do not need to show an error by the magistrate. So basically, there's four different types of appeal. There's an appeal stricto sensu, which we said was the type of appeal under Section 105. You have to be able to show an error. There's an appeal by way of a rehearing, either with additional evidence or not. But in an appeal by way of a rehearing, the court has to come to its own view based on the evidence that's placed before them. And that is the nature of an appeal under 113. But the CFA also mentioned a fourth category of appeal, which is an appeal by de novo. That's basically what we understand to be a retrial. In other words, the appellate court does not consider the underlying decision of the magistrate. It conducts a full retrial. And this procedure, although it's technically possible in other jurisdictions, is not something that we see in Hong Kong. Why not? Because none of our statutes give the power to the appellate court to conduct a full retrial. And a full retrial would be where the witnesses are called and they testify in court. What the courts on appeal can do is order the court of originating jurisdiction to conduct a retrial. But an appeal de novo is where the appellate court actually conducts the retrial. And that provision or that power is not something that we see in our statutory provisions in Hong Kong. Where fresh evidence is introduced, then the Court on Appeal in the CFI and CA have a limited right to consider testimony regarding that fresh evidence because it was never introduced in the original trial, but it's not what we consider to be a full appeal de novo. So basically, the CFA said that where you're appealing under 113, it's not necessary for the CFI judge to be satisfied that the magistrate was plainly wrong, illogical, or inherently improbable, nor does the appellant need to identify any particular error. Instead, they have to conduct a rehearing and reach their own conclusion. If they're satisfied on the prosecution's evidence that the defendant's guilt has been proved beyond reasonable doubt, then the conviction stands. Otherwise, it should be quashed. So I would read that case because I think it's a recent important decision on the powers of the court on a magistracy appeal. What else can the CFI judge do when he's conducting or listening to an appeal from the magistrate's court? So I've said he can introduce fresh evidence on appeal, and all the section says is just if necessary. But the test is this fresh evidence likely to be credible? Would it have been admissible in the court below? And it wasn't admitted, but there's a reasonable explanation for this. So we're talking about things like there has been material non-disclosure from the prosecution. So that's why we need the fresh evidence to be introduced. Or a new witness has suddenly come to light that we didn't know about previously, or new evidence has suddenly been discovered, or perhaps evidence has been fraudulently withheld. Those would all be giving reasonable explanations for not admitting this fresh evidence at first instance. The CFI judge can also do what I call pass the hot potato. Okay, and this is the power in section 1181D for the CFI judge to basically say, I don't want to deal with the points in this appeal because I feel that they are particularly complex or perhaps they are novel, new reasons we've never considered before. So I think it's much more important for the Court of Appeal to consider them so the Court of Appeal can lay down some guidance. And that's exactly what happened in the Kelvin Y.C. Learn case. And I referred to this case before as a terrible example of where case management, court etiquette spiraled way out of control. And what should have been a very simple 2-day trial in respect of a domestic helper who had been hit by a taxi and she'd sustained some personal injuries. and she was then prosecuted for negligently endangering her own safety as a pedestrian, right? Who knew that was an offense in law? I mean, most victims of traffic accidents actually is the driver, right? Who's the only person to be prosecuted. I'm not sure if it was because of the fact that she was a domestic helper. Maybe that's why she was prosecuted or targeted in particular. The evidence seemed to be that she had crossed the road in a really unsafe place. She crossed on a bend in the road. But generally, of course, as a pedestrian, even if you cross in an unsafe place on the road, it doesn't mean that the driver is not liable for hitting you. And she actually took out an action for personal injuries. And so in this case, in the original criminal prosecution, I think the maximum penalty that she could have gotten was a small fine. But this case stretched on to like 91 days. One of the reasons was that there was a lot of animosity between the defense counsel and the magistrate involved. So there was a lot of bickering. There was a lot of disagreement about refixing of trial dates. Like defense counsel at one point said he had an important holiday booked that he couldn't miss. Another time he said he couldn't appear in court because it was his child's birthday party. And then at one point, he said that he couldn't do a particular day because he had a conflict in another case. Now, usually, the magistrate's very accommodating when it comes to counsel's professional diary. So they will allow a different date if client has a clash with another case. But for some reason, maybe because of the bad blood between them, magistrate didn't believe the defense counsel in this case. And the defense counsel, when he didn't appear, the magistrate actually issued an arrest warrant against the defense counsel. And at that point, the defense counsel stepped down. But prior to that, there'd been a lot of bickering back and forth between the defense counsel and the magistrate. Like at one point, the defense counsel said to the magistrate, "Are you insane?" Let me just, sorry, I think my internet connection may have been a bit unstable there. I was just going through the Kelvin YC Learn case, and I was saying that when defense counsel didn't appear in court, and the magistrate actually issued an arrest warrant for his arrest. And there'd been a lot of bickering. The magistrate had been criticized by the defense counsel for being insane. Um, and once the defense counsel stepped down, the solicitor then took over the case, but the bad blood continued. And I think the solicitor actually implied at one point that the magistrate was in the prosecutor's pockets. And the magistrate then referred to the solicitor saying, good boy, like very patronizing. So on appeal, when this went up to the Court of Appeal, they were incredibly critical of all of the parties involved, but most notably the defense counsel for launching a personal attack on the magistrate, but also an attack on the bench as a whole, right? Because calling the magistrate insane is an attack on a judicial officer. And so they recommended disciplinary proceedings for that counsel. But the Calvin YC Learn case is actually a case about a wasted costs order because the magistrate had imposed wasted costs orders on the defense counsel and on the solicitor personally. Um, and so that's what that case is about. But the Court of Appeal say because of the complex nature of this case, this was a very good example of a case where it was appropriate for the Court on Appeal to consider this rather than a judge in the CFI. But a judge in the CFI can also confirm, reverse, or vary the magistrate's decision or remit the case to them with a direction to deal with the issue in a particular way. So, for instance, they can order a retrial by the magistrate, and they can exercise any power that the magistrate could have made. Now, in the CFI, if it's an appeal from a magistracy decision, this power to apply the proviso does not apply. We'll look at the proviso when we get to appealing to the CA. But the proviso, just to briefly introduce it, is where the Court of Appeal can say on an appeal, although you technically have good grounds of appeal, we are satisfied that there has been no miscarriage of justice. Therefore, the defendant's conviction stands. Now, that does not apply to a magistracy appeal. Why not? Because there is no such statutory provision applying the proviso in a magistracy appeal. The proviso in the CPO only applies to a district court and CFI appeal. So just make a note of that. But the CFI judge can also substitute the conviction for another offense that the defendant could have been convicted on at the trial, like if the prosecution established the elements of another offense. They can also increase or decrease the sentence. And it's important if you are appealing to warn your client that a consequence of the appeal could be that his actual sentence is increased on appeal. So, on appealing from the MC to the CFI under 113, then the CFI judge can quash the conviction, but they have to conduct a rehearing and to be satisfied that the defendant is guilty beyond reasonable doubt. So what I did in this next chart is summarize the different provisions of Section 105 and 113. So you can see everything that I've just told you. 105 has to be an appeal on a question of law, but if you're appealing a question of fact for the defendant, he can use Section 113, subsection 1 or 2. Okay, different time provisions because extension of times possible under 113, but not 115. And then different types of appeal as well. So you can read that, I think, in your own time. Okay, does anyone need me to repeat anything so far if we lost the connection at any point? Only 61 of you online. Hey, obviously, the other 39 or so don't think that an appeal lecture is an important topic. Or perhaps they just have better plans, right? It is the night before a holiday, right? So it's the worst possible time to be having such a crucial lecture. And I tried hard to look for a better date, but unfortunately, there just wasn't one. Let's see. Question, hold on. The calendar. So, in the exam, because you need to calculate the last date to lodge your appeal, just to cover yourself, I would bring in a printed copy of the calendar for November this year, December 2025, because that's when your exam will be, as well as January 2026. Okay, because the longest appeal period is 28 days. Okay, so you won't need anything further than January 2026, but you've got to have a printed copy, right? Because just counting on your fingers is not going to tell you if the last day is a public holiday. Okay, and we'll see that there are some different provisions where the last day is a public holiday. All right, let's look at reviewing a magistrate's decision under 104. This is not an appeal. An appeal is to a higher court. This is where you go back before usually the same magistrate who's made the decision or convicted the defendant or sentenced him, and you ask him to reconsider it. It's open to either the prosecution or the defense, or even the magistrate of his own motion can choose to review his decision. And he may well do so where subsequently he realizes he made an error. Now, sometimes that may be because, let's say, a very important decision had just been handed down by the Court of Appeal the day before and he wasn't aware of it, or neither party drew it to his attention, right? So sometimes these errors can happen inadvertently. But it's important that you think carefully about whether to proceed under 104 or to appeal, because you can't do both. If you've already lodged an appeal and you change your mind and decide you want to use the 104 review, then you have to withdraw your appeal first. So you can review, it's very wide, any decision or determination of a magistrate in any matter. You have 14 clear days to do it, and it's against any order or determination. So it could be against a decision not to admit evidence, for example. That's a decision that's made. It doesn't have to be a decision in relation to conviction or acquittal, but you can't get an extension of time. And because it references clear days, day one is not the day of the decision, it's the following day. But when the magistrate reconsiders his decision, he can reopen the case in whole or part, he can admit fresh evidence, he can reverse, vary, or confirm his original decision. So it's quite useful to go back before a magistrate if a very simple and obvious error has been made. But you wouldn't go back to review a magistrate's decision if your grounds of appeal were that the magistrate was biased or incompetent in some way, right? Because save that for another judge, right? Rather than arguing those points before the same magistrate. So why would a defendant choose to review? It's basically cheaper because you're staying within the magistrate's court rather than instructing counsel for an appeal to the court of first instance. It's also much quicker because you're going back before someone who's already familiar with the facts and the issues, so you don't need to spend time going over that at the start. And also, it can sometimes take a long time to get a day for an appeal in the CFI. But not suitable if you're alleging bias or improper behavior or the magistrate has failed to correctly exercise his discretion. Now, if the magistrate refuses to review his decision, you cannot appeal his refusal to hear your review. But of course, you can appeal his original decision, okay? Either under 105 or 113. Okay. If the magistrate hears your review application and overturns his original decision, then that new decision can, of course, be appealed by whichever party is aggrieved with it. Okay. And time starts to run from the date of that review decision. But just remember, if he says, no, I'm not hearing your application for a review, you can't appeal his refusal. You'd have to appeal his original decision. The other option under where we have been convicted in the magistrate's court is for the SJ to review the defendant's sentence to the Court of Appeal under Section 81 of the CPO. Sorry, 81A of the CPO. And the grounds are that the sentence is manifestly inadequate. Rarely would the Secretary for Justice review on the grounds that the sentence is manifestly excessive, but it could happen. Remember, the prosecution's objective is not to secure the harshest sentence that could be imposed, but one that is reasonable in the circumstances. Or you could argue that the sentence was outside the court's jurisdiction or wrong in principle. The SJ has 21 days to apply for this review, and they apply in writing. And then if we are appealing against conviction or sentence for a juvenile, then of course, if it is within the juvenile courts, then they have the same rights of appeal as any adult would do under the magistracy provisions. If they've been convicted to another court and then remitted to the juvenile court for sentencing, then that's the same provision as well. Remember that a juvenile could be convicted by another court if it is, say, like an indictable offense and they are alleged to have committed this offense with an adult. The juvenile could be tried in the district court or in the CFI, for example. Okay, so we are making very good progress through our slides. What I'm going to do before we take a break is we're going to go on and we're going to do a few more provisions. And so that when we come back after the break, we can really focus on grounds of appeal for defendant against conviction and sentence. Okay. So let's move on now to looking at the different options where defendant has been convicted and sentenced in either the district court or the CFI. And this is always an appeal to the Court of Appeal. So from the prosecution's perspective, if the defendant is convicted in the district court, they can use the provisions of Section 84 of the district court ordinance. Sorry, I should have said if the defendant is acquitted. If the defendant is acquitted in the district court, the prosecution can appeal that acquittal under Section 84 of the district court ordinance by way of case stated. Okay, but that provision, Section 84, obviously only applies to an acquittal in the district court. We'll look at that in a minute. There is also the power of the prosecution to refer a question of law following an acquittal in either the DC or the CFI under Section 81D of the CPO. This is where they ask the Court of Appeal to consider a question of law, but it's not an appeal. The Court of Appeal won't overturn the original acquittal. They can also appeal against a discharge or an order quashing the indictment. They can review sentence under 81A. We just looked at that. And then there is new provisions to consider to appeal an acquittal by a panel of 3 judges in a national security case. From the defendant's perspective, he can appeal his conviction and sentence either under Section 83 of the DCO as well as under Part 4 of the CPO. And there is this limited power to reserve a question of law under Section 81 of the CPO as well, but I wouldn't worry too much about that. I do, though, want to go on and consider Section 84 of the District Court Ordinance, which is the prosecution's ability to appeal by way of case stated against the defendant's acquittal in the district court. Right, so a couple of points to note at the start. First of all, this provision, Section 84, only applies where the district court was the court of trial. Okay, doesn't apply if the CFI or the MC was the court of trial. Secondly, it only applies to the prosecution, okay, because obviously the defendant is not going to wish to appeal his acquittal. Hey, sorry guys, you let me out, but really I'm guilty. I want to appeal my acquittal, okay? And you can see from the title that it's an appeal by way of case stated. So what we know already about appeals by case stated are they are limited. You can only appeal on a question of law. So before we go any further, let me just stop sharing this and let us look at the provision of the district court ordinance. If you guys want to bring this up yourself as well, the same time, that's helpful. I'm going to look at section 84 of the District Court Ordinance. Always helps, right? If we look at the law, the statutory provisions as we are going through the slides. One of my students very strangely asked me the other day, I've actually never been asked this question by a student before. They asked, is it possible for us not to have to read the cases or the statutory provisions? And I almost fell off my chair. I couldn't believe I'd heard this correctly. There's no way you can be a lawyer if you don't read the cases or the statutory provisions, right? I mean, I know we have AI these days, but like breaking news, AI is not a lawyer, right? And so AI will make errors. Even the learned authors, editors of Archbold make errors, okay? So it's always best to do the work yourself and to review the statutory provisions as well as the case law, right? Of course, you know, you could use AI as a shortcut to help you identify where to start, but you yourself have to do the groundwork. All right, so this is section 84 DCO. An appeal shall lie by the SJ against a verdict or order of acquittal, okay, including an order quashing or dismissing a charge for any defect or want of jurisdiction. Okay, so it has to be against an acquittal. Such an appeal shall relate to matters of law only. Okay, and now here we have the procedure. Within 7 clear days after the reasons for verdict or after the order of acquittal, etc., etc., you have to apply in writing to state a case, setting forward the facts and the grounds of the appeal. Okay, and then you consider the provisions in the magistrate's ordinance dealing with appeals by way of case stated. Okay, so there's the procedure. 7 clear days. You can get an extension of time on this. Now, what can the Court of Appeal do? If we look at subsection C, the Court on Appeal shall, if it is satisfied there's no sufficient ground, dismiss the appeal. I'm getting a few signals that my internet connection is unstable, but I think for the large amount, it seems to be okay. I'm not sure if it's your internet signals that is the issue, okay? But if it continues after the break, then I'll try relocating. But if you want me to repeat anything, just let me know, okay? Is it very unstable? Okay. All right. So can you hear me now, okay? Just confirm if you can hear me now, and I will just finish off this slide, and then we'll take a break, and we will go back. After the break, I'll move to a different location, okay? So we're dealing with section 84C of the DCO, and these are the powers of the Court on Appeal. So if there are no sufficient grounds for interfering, it can dismiss the appeal, or the CA can reverse the verdict, direct the resumption of the trial, or that the accused be retried, or find him guilty, record a conviction, and pass any sentence on him as may have been passed below, and then give consequential directions. Right, so according to subsection C2, the Court on Appeal can resume the trial. Let's say if the defendant was acquitted at the no case to answer stage in the district court, they can order the resumption of the trial, or they could order the retrial of the accused if he was acquitted at the end of the trial. So the district court has to start again with a new trial, or they could convict the defendant and sentence him. Now, this is the real controversial part of subsection C, because this is giving the Court of Appeal the power to convict a defendant even where they have not heard the testimony from the witnesses, right? Because remember, the Court of Appeal doesn't have witness testimony. It's just looking at the grounds of appeal on paper, okay? So actually, this provision is a very good example of why you should never rely on the statutory provision itself. You always have to look at the underlying case law as to how it's interpreted these statutory provisions. And if you look at this case of SJ and Wong Sao Fong, then it tells you that actually this provision is unconstitutional. Because remember, Article 11 of the Bill of Rights, the defendant has a right of appeal. And if the Court of Appeal convicts the defendant, there is no right of appeal to the CFA. The CFA will only intervene in limited circumstances if you can establish basically the two limbs of appeal to the CFA. Okay, so that was held to be unconstitutional. So basically, that ability in Section 84, subsection C of the Court of Appeal to convict the defendant no longer exists in law. But it does mean that an acquittal in the district court is not final. The prosecution can appeal it by way of case stated, assuming they meet these tests and use the relevant procedures, and the court on appeal could direct a retrial. All right, I will take a break now. I will move to a different location and then I will come back and I'll go back over it. Okay, deal? So it is 7:52. Let's come back at 8 p.m. and I will try and relocate myself to somewhere where the internet connection is stronger. What? Somehow my Wi-Fi knows when I'm getting to the important bits, and that's when it cuts out. That's what we call in English sod's law, right? Um, in other words, like, of course that would happen on the most important points. It's not going to cut me out when I'm saying something that's complete nonsense or irrelevant. Okay? All right. Let me find a better spot and we will review again when I pick back up. Okay? So let's come back at 8 o'clock. Okay? 8 o'clock we'll resume. All right, everyone, just checking you can hear me. Okay, good. Let's try out here, see if it's a bit better. Um, Unfortunately, what it could be is lots of people coming home and starting to connect into my building's Wi-Fi. Um, I don't generally like to teach out here because what will happen is you'll probably get a succession of cats wandering across the screen as I'm in the middle of teaching. But anyway, okay, so let's recap. We were looking at Section 84 of the District Court Ordinance and the prosecution's ability to appeal by way of case stated. But it has to only be against the defendant's acquittal and it has to be on a question of law. And we looked at the statutory provision in Section 84. Prosecution have 7 clear days to appeal. That means that they start counting the day after the acquittal, but they can get an extension of time. Because it's an appeal by way of case stated, they would still have to use the same provisions as in the magistrate's ordinance. So, this very time consuming, cumbersome method of appealing. Um, but we were focused just before we ended, and the internet connection was not very good, on the powers of the CFI in particular under Section 84, subsection C. So let me just stop this. Let's go back to what we were looking at, which is that provision in the District Court Ordinance. Hold on a second, clicked on the wrong one. Okay, here we go. All right, so under this provision, on an appeal against the defendant's acquittal, the Court of Appeal can dismiss the appeal. So, in other words, the acquittal stands. Or they can reverse the order, direct that the trial be resumed. So, when would they do that? Let's imagine that the defendant was acquitted at the no case to answer stage, right? Then they could order the trial to continue on into the defense case. Or they can order that the accused be retried. In other words, the district court has to conduct a fresh trial. Or they can find him guilty, convict him, and then sentence him. Now, it's really this highlighted bit of subsection C that's controversial because this is giving the power to the Court of Appeal to overturn the defendant's acquittal and to convict him themselves and then sentence him without hearing any testimony from any witnesses. Because remember, the Court on Appeal doesn't hear testimony from the witnesses. Okay, so it was that provision that proved to be very controversial. And this is a good example of why you can never just look at the statutory provision. You have to look at the underlying case law as well. So if we go back to our slides, this case of SJ and Wong Sao Fong, this is a great example of the statutory provision being reinterpreted by the court. And the court said that that power to convict an acquitted defendant is actually unconstitutional. Because remember, in Article 11 of the Bill of Rights, a defendant who's convicted has the right to an appeal. And if the Court of Appeal convict a defendant for the first time because he was acquitted in the district court, then he has no right of appeal because there is no right of appeal to the CFA. You have to get leave to appeal and you have to be able to bring your appeal grounds within one of the very limited limbs that exist for an appeal to the CFA. However, they can do the other things. They can set aside the acquittal and direct a resumption of the trial or a retrial, or they can dismiss the appeal. So, Section 84 DCO, an acquittal in the district court is not final. It can be appealed by the prosecution as long as they can satisfy the criteria in Section 84. But remember, it only applies to an acquittal in the district court. It does not apply to an acquittal in the CFI. If the defendant is acquitted in either the CFI or actually the district court as well, then the Secretary for Justice has the option to refer a question of law to the Court of Appeal. But where the defendant is acquitted by a jury in the CFI, then the SJ has no power to appeal the acquittal. All that they can do is refer the question of law. So where the jury acquits after trial, that acquittal is final because the CA cannot overturn it on appeal. Why not? Because there is no statutory basis for them to be able to do so. Okay? So just remember an acquittal by a jury following the trial in the CFI is final and cannot be appealed. And the defendant, if acquitted by the jury, should be hot-footing it out of Hong Kong ASAP to make sure that the statutory provisions are not amended in any way, like we've seen in recent years with some of these provisions. And this is a good example. So previously, even if the jury had been told by the judge to acquit, right? So they'd been directed to acquit because the judge had ruled that there was no case to answer. Previously, that could not be appealed either because an acquittal by a jury at any stage in the case was final. But in 2023, this Division 3 of the CPO was introduced so that now the SJ can appeal with leave following a no case to answer ruling if it does so as soon as practicable. No guidance in the provisions about what that means, but obviously they would have to act quickly because if the defendant is granted bail, then they could be out of the jurisdiction depending on the conditions. This doesn't apply to appeals under the NSL, but it does mean that under these sections, the Court of Appeal can order the resumption of the trial or a retrial, or they can uphold the acquittal, but only if they're satisfied that the Court of Appeal, that the defendant could not receive a fair trial. Okay? So these are new provisions allowing the prosecution to appeal defendant's acquittal by a jury following a no case to answer. Okay, now a no case to answer submission, remember, is a question of law for the judge to decide on, and the jurors are the deciders of fact. But the jury reached the decision on conviction, right? Which is why if the judge in the CFI rules there's no case to answer, what they will do is then direct the jury to acquit. Other option is the SJ's appeal against the defendant's discharge. If that happens after a Section 16 discharge, they could appeal it. I wouldn't worry too much about these provisions at all. Just be aware that they exist in Section 81E and Section 81F as well. The ability to appeal against an order quashing the indictment, that could also be appealed. And then, of course, we have the SJ's ability to review sentence under Section 81 of the CPO. Same powers in the district court and CFI as in the magistrate's court as well. Okay, so is that clear now that I've gone back over the provisions in the district court to appeal against the acquittal? Anyone still confused? I think it's fairly straightforward once you have read the sections. Okay. Okay, let's move on to, we've covered this already. This is the ability to appeal by way of case stated, where a panel of 3 judges acquit the defendant in a national security case. This was introduced specifically because of concerns raised by the courts that there was no ability to appeal an acquittal where the trial was held in the CFI. This only applies in national security cases. The SJ has to find a ground of appeal that is a question of law, but they have 14 clear days with an extension of time to appeal. However, if the defendant's national security case is heard by a jury in the CFI, then remember, if the jury acquits after the trial, that acquittal is still final. Okay, so far in the CFI, we have not had a trial by a jury in a national security case. The SJ has always issued the certificate for trial by a panel of 3 judges. Okay. And I think there's a number of reasons for that. Firstly, they want to preserve this right to appeal and acquittal. But secondly, also because we're dealing with new complex areas of the law that are politically sensitive, deal with state secrets, matters of national security, the best people to make those decisions would be this specially selected panel of 3 judges. Okay, so let's move on to defendant's appeal against conviction in the District Court CFI. This is an appeal to the Court of Appeal, and you have to look at the provisions in the CPO. Okay, now if the defendant is convicted in the DC, then these particular provisions of the CPO apply. Why is it significant? We will see in a minute that Section 83Z of the CPO does not apply to a defendant convicted in the district court. So just bear that in mind. We will discuss it in a minute when we get to bail pending appeal. Okay. But what is different between an appeal from the DC CFI to the CA versus a magistracy appeal is that even if the defendant pleaded guilty in the district court or the CFI, he can appeal against his conviction. Why? Because the statute gives him that power. Whereas in the magistrate's court, the magistrate's ordinance specifically does not allow a defendant who pleaded guilty to appeal his conviction. Okay. He would have to look to withdraw his guilty plea. Okay. Now, do you need leave to appeal to the CA? You don't need leave if it's a question of law or if the trial judge grants you a certificate of fitness for appeal, but you do need leave to appeal a question of fact or a mixed question of law and fact. Now, how do we determine what's a question of law? So, a question of law is something which is only possibly involving a ground of appeal on a matter of law, so a wrong decision in law. On the other hand, a question of fact is, for example, were the defendant's fingerprints found on the murder weapon? Did the police officer threaten the defendant? Okay. Now, for your purposes in the exam, almost always the grounds of appeal that you identify, and you'll be identifying several grounds of appeal, right? It would be very strange if all of the grounds of appeal that you identify are questions of law only, okay? So just remember that for your purposes in the exam, you're likely to have a combination of grounds of maybe law and fact, which will require leave to appeal. Now, often your grounds of appeal are both questions of law and fact, right? If we take a challenge to the admissibility of a confession, let's say defendant alleges he was beaten up by the police officer. That's a question of fact, but the admissibility of that confession is a question of law. Whether to hold a voir dire to investigate the admissibility of the confession is a question of law, right? But as to why you may need a voir dire, those are usually question of fact. So that's a combined question of law and fact. So you will need leave on that point. But examples of strictly just questions of fact, for example, are the premises, or let's say, was force used was a knife used to commit the robbery, right? Then that is a question of fact. The grounds of appeal are set out in Section 83 of the CPO, but they're not fixed in any way. And there's a lot of overlap between these 3 different heads of appeal. So you can see a lot of confusion in the cases. Sometimes what has been held to be one ground of appeal in one case, in another case has been held to be a different ground of appeal. So first ground of appeal is that the conviction is unsafe or unsatisfactory. So, for example, there's a lurking doubt, just a general unease about the conviction, or that the judge um, descended into the arena. In other words, the judge took on the role of counsel in the case, so much so that counsel was prevented from doing his job and asking questions of the witness, or the witness could not answer the questions. Now, a judge is always permitted to ask some questions in the trial, usually just to clarify matters, or sometimes on important matters that counsel has not asked about, but not to conduct the case, not to launch into a cross-examination of the witness himself. So that would be a very good ground of appeal. Other grounds of appeal, bias. Would a reasonable and fair-minded, well-informed observer conclude that there was a real possibility that the judge was biased? So you may have to ask for the trial transcript to consider comments that the magistrate made. For example, giving his opinion that the witness was lying or making things up or fabricating. That may be a good example of evidence of the judge's bias. Misconduct by the prosecution or the investigating authority. We saw this in the Ng Chong To case, Raymond, that we looked at. Remember, we looked at this in the context of a permanent stay application. That permanent stay application was refused, but a retrial was ordered in the case because of the misconduct of the ICAC officers. Another good ground of appeal could be flagrant incompetence by counsel, but I want you to bear a couple of points in mind. Firstly, this is a high threshold to meet in practice. The court is reluctant to allow a ground of appeal that's just a tactical decision that, with the benefit of hindsight, you would have done differently. It really has to be flagrant incompetence, so not just a mere error of judgment, because the overriding question is, did the defendant receive a fair trial? So, for example, in Ho Chung Wah, the defense counsel's deliberate failure not to put certain instructions of the defendant to a witness, that was held to be flagrant incompetence because that was critical to the defense. But it's a very high threshold to succeed on appeal. You may be able to take several errors that counsel made and combine them together to demonstrate flagrant incompetence. But things like, for example, failing to put the defendant's clear record in the admitted facts, that's been held to be flagrant incompetence as well. Judges' failure to properly evaluate the evidence. For example, the judge has failed to resolve inconsistencies in the evidence between witnesses, or in that Saeed Rashid Aslam case, it was failure to resolve or to consider the animosity between the prosecution witness and the defendant. Where the judge's summing up was unfair and unbalanced. Now, the judge has this overriding obligation to make sure that in summing up the case to the jury, he doesn't excessively emphasize the prosecution's case over that of the defense. So where the defense has called witnesses and raised issues in their defense, those should be accurately summarized for the jury. So, for example, in the Huang Roifang case, which you should be familiar with, this is the case that we looked at in LGS 8, where we looked at the revised tariffs for sentencing in heroin and cocaine. So, a very important case to read. In this case, the defendant's defense was that she was not a drug trafficker. She was merely a drug smuggler. And so she introduced WeChat messages between herself and other smugglers in which they discussed like tactics for getting drugs into Hong Kong. And she also introduced a video basically warning drug smugglers about the dangers of their occupation. And the judge in that case failed to properly put the case to the jury that the defense was that she was a smuggler and not a trafficker. And he also inaccurately summarized the evidence. He made excessive reference to the prosecution cross-examination of the defendant as to whether she was a trafficker or not. So, as a whole, his summing up was unfair and unbalanced and was a miscarriage of justice, sufficient that the conviction was actually set aside. In the another example could be a misdirection to the jury amounting from an error of interpretation. And it has to be a significantly important error of interpretation, right? Not just a very minor discrepancy. Okay, in the Pak Lun case, this was a murder case in which there were several defendants involved who had all, I think they were all quite young boys, and they had attacked as a gang the witness who had, the victim who had subsequently died. And actually, the judge asked one of the defendants a question about whether he appreciated the risk that the participants intended to cause grievous bodily harm. Okay, so for murder, you don't just need to you don't just need an intention to kill. It's sufficient if you have an intention to cause grievous bodily harm. So that was the question that the judge asked the defendant. But when it was interpreted to the defendant, the interpreter mistranslated it as, did he appreciate that the participants intended to cause bodily harm? And he left out grievous bodily harm. And the defendant agreed. So the judge then directed the jury that the defendant had essentially admitted committing murder. So they had to convict him. So that was a serious error of interpretation, which means that when you are the trial counsel, you really have to be switched on at all times, listening carefully to every single question that's asked, looking carefully at everything that's going on in court. Question: will flagrant incompetence of counsel lead to a civil claim for professional negligence? Yes, it could well do. It could well be grounds for a civil claim as well. Because remember that if flagrant incompetence of counsel has been established in a criminal case, because it's such a high threshold to succeed on that as a ground of appeal, it's likely to be very good grounds for any civil lawsuit. Okay, just give me 1 second. Let me just pause for a minute. I'm just going to have a quick sip of my drink. Hi there. Sorry, just also giving some instructions around the house. Okay, so next ground of appeal, wrong decision of law. So here it has to be a material wrong decision. So it could be a misdirection to the jury, right? Directions to the jury are on questions of law. It could be wrongfully including or excluding evidence, or sometimes even the wrongful exercise of the judge's discretion. Although overturning the judge's discretion is always difficult on appeal, unless it's a very plainly wrong error that has been made. And that's what happened in the Zoli May case. Actually, what the defendant had said was so equivocal that it didn't actually amount to a confession. Basically, the defendant, when she was stopped with a suitcase full of drugs, was told by the officer that they'd done a test and that it had conclusively established that they were drugs. And then they asked her, well, what is this powder? And she said, I suppose it's drugs. And that was put to the defendant as evidence, put to the jury as evidence of her confession. But the Court on Appeal said, in that case, the confession was so plainly equivocal that it should not have been left to the jury as a confession at all. The other ground of appeal is a material irregularity in the course of the trial. So again, we see here failing to exercise discretion. And this is what I mean about lots of overlap between the different grounds of appeal, because this can also be a wrong decision in law, or it could be something that renders the conviction unsafe or unsatisfactory. So in your exam, I don't want you to panic about trying to identify whether the grounds of appeal that you can spot are wrong decisions in law, material irregularities, or convictions unsafe or unsatisfactory. You don't need to put your grounds of appeal into one of the three buckets. You just need to identify what your grounds of appeal are. Okay? But the prosecution referring to inadmissible evidence in opening, like prejudicial hearsay statements, very good ground of appeal, and would usually lead to the jury being set aside. Also, if the prosecution refers to the defendant as being the target of a police operation, that's really prejudicial because it implies that the police have prior knowledge of the defendant's criminal activities. So it's strengthening the case against the defendant in a way that would be very unfair, particularly in the eyes of the jury. However, in the Shakil Ahmed case, it was actually the defense counsel that kept referring to the defendant as the target. And then they tried to appeal, basically saying that the reference to the target was a material irregularity and his conviction should be set aside. And the court, of course, said, nonsense. You were the ones who introduced it. You can't rely on it as a good ground of appeal. And it was done in Shakil Ahmed by defense counsel specifically because the whole line of defense was that the defendant had been framed. So they said, having run that line of defense, having introduced the fact that he was targeted, you can't now complain about it on appeal. Failing to correct reference to inadmissible evidence in closing, that's a good ground of appeal as well. Irregularities in the verdict. We are familiar with the case of Hazeltine from our earlier SGS. Remember that if the prosecution have refused an offer to PG to a lesser alternative offense, then in order for the defendant to be convicted of that after trial, has to be on the basis that the prosecution have proved the elements of the offense. Failure to disclose material information, also a good ground of appeal. And then I put this case in Learn Why Kit because it's a recent case. This deals with where the defense counsel has not done what we call put the case this should say not the jury, it should say a prosecution witness. So defense counsel failed to put the defense case to a prosecution witness. Okay, let me just correct this. In accordance with the rule in Brown and Dunn. So those of you who remember from your evidence law lectures, the rule in Brown and Dunn is a rule of evidence, and it's essentially a rule of fairness. What it is that you must question a witness in cross-examination about all material aspects of their evidence that you intend to argue in your closing submissions are incorrect, right? So if your case is that the prosecution witness is lying, you must put to the witness in cross-examination that they are not telling the truth, and you must give them the opportunity to answer that allegation against them. If you don't, then under the rule in Brown and Dunn, you cannot argue that in your closing submissions. Now, what the judge did here in this Learn Why Kit case is he commented to the jury about defense counsel's failure to put certain aspects of the defense case to the prosecution witness, and he suggested that it could be because defense counsel didn't feel that they were merited or valid. And the Court on Appeal said, well, defense counsel may have many reasons for failing to put that to a prosecution witness. Defense counsel may, for example, just be incompetent, right? So that was a material misdirection to the jury. So a couple of key points to appeal conviction. Firstly, very hard to overturn findings of fact or matters of discretion in the court below, okay? Because the Court on Appeal has only limited scope to consider what's before it on appeal. In the UK now, there's only actually one ground of appeal, and that's unsafe and unsatisfactory. The reason for that is because there was so much overlap between the different grounds of appeal. So they've abolished wrong decision in law and material irregularity. In the UK, it's unsafe and unsatisfactory, right? But in Hong Kong, our provision says unsafe or unsatisfactory, which makes you think it's one or the other. Actually, in practice, there's no real difference between unsafe and unsatisfactory. And in fact, you see lots of cases in which the courts in Hong Kong mistakenly say unsafe and unsatisfactory. So don't worry too much about the difference between them. But here's the proviso that I was referring to earlier on. Section 83 of the CPO, provided that the Court of Appeal may, notwithstanding that it's of the opinion that the point raised in the appeal may be decided in favor of the appellant, dismiss the appeal if it considers that no miscarriage of justice has actually occurred. Okay? What does it mean in practice? This is what I call the too bad, so sad card. This is where the Court of Appeal basically says, sorry, defendant convicted in the CFI or district court, we agree with you that something technically went wrong in your appeal, but nevertheless, we consider you to be guilty. There has been no miscarriage of justice. We are satisfied that even if this error hadn't occurred, you would still have been convicted. So the case comes from Kulinessen. Would a reasonable jury properly directed, without a doubt, have convicted or inevitably have come to the same conclusion? If so, they will apply the proviso. So the appeal will be dismissed, even though technically there may have been good grounds of appeal. Now, the Court of Appeal has also said that they will not apply this proviso if they find the conviction to be unsafe or unsatisfactory, because a conviction which is unsafe or unsatisfactory must have resulted in a miscarriage of justice. Okay? So just remember that if the conviction is unsafe or unsatisfactory, the proviso cannot be applied, and it cannot be applied in magistracy decisions, to magistracy appeals also. But the CA can dismiss the appeal, conviction stands, quash the conviction, substitute a conviction for an alternative offence, or they can order a retrial in the interests of justice. If, for example, the offence is serious, if there is sufficient evidence, and it is in the public interest to do so, so the prosecution can still meet their prosecutorial test. If there has not been such a long delay that crucial evidence has disappeared, if the offence is serious so that the likely sentence would be long, then they will likely order a retrial. Okay, let's move on to consider appeals against sentence in the district court and CFI. Remember always, cannot appeal a sentence fixed by law, like murder, for example. Okay? If the defendant is 18 or above, commits murder, must be sentenced to life imprisonment. Okay? Below that, it's a discretionary life sentence. So you could appeal that. You can also appeal a mandatory sentence, right? Remember, we looked at Section 33, Public Order Ordinance, possession of an offensive weapon. And we looked at how, depending on the age of the defendant, certain sentencing options were possible. So let's say he was between 17 and 25. There were three options: imprisonment up to 3 years, detention center, or rehabilitation center. So you could appeal the type of sentence that was imposed and argue that a different type within that mandatory regime should have been imposed. So you sentence him to imprisonment, but DC or RC was more appropriate. So you could appeal the type. But if he's sentenced to imprisonment, for example, of 3 years, then you could appeal the length of that imprisonment. But you always need leave to appeal sentence, Section 83I. So if you're appealing conviction and sentence, you will need leave. What can you argue? That the sentence was imposed in excess of jurisdiction. For example, Magistrate sentenced to 5 years, he's restricted to 2. That's rare, obviously. You can argue that the sentence was wrong in principle. What that means is the wrong type of sentence was imposed. So he was imprisoned, but he should have got probation. That's what we mean by wrong in principle. Or you can argue that the judge sentenced on a wrong factual premise. In other words, he took the wrong facts into account. Let's say he got the defendant's age wrong, or his number of previous convictions wrong, or whether the defendant had a clear record or not, or whether the premises was residential or commercial in the case of burglary, right? For burglary, there's a higher starting point for burglary of residential premises because of the risk to life. So if the judge is sentenced on wrong facts, you could appeal on a wrong factual premise. If there has been a significant alteration in circumstances since sentence was imposed, and the appellate process is still what we call extant, that means ongoing, then the defendant may be able to benefit from a significant alteration in circumstances. For example, where tariffs have been revised as a result, and that revision would have given the defendant a more lenient sentence if those tariffs had been in place at the time he was sentenced. That's the Seabrook case. Now, if the tariffs have been revised upwards, then no appeal against sentence would be granted just based on that ground alone. But if the tariffs have been reduced, then the defendant could appeal that reduction in his tariff. Or if he's given assistance to authorities after he was sentenced. Remember that at the time of sentencing, a mere promise to assist in the future will not be taken into the account by the court as a mitigating factor. At most, the court will only adjourn sentencing until the value of that assistance can be assessed. But the other alternative is that they proceed to sentence, and then later on, the defendant has to then appeal that sentence if he's given assistance to authorities later. Obviously, that's not ideal because you're then having to undo something that was done earlier. So another ground of appeal, the sentence is manifestly excessive. That means not just a little bit too high. Manifestly excessive, we are meaning something outside the realm of the judge's sentencing discretion. And of course, we could appeal on the prosecution's basis if it is manifestly inadequate. But of course, the defendant would never appeal his sentence on that basis. Now, actually, I'm going to amend this first bullet point on the next slide, because it should say powers of the court on appeal against conviction and sentence, okay? A defendant, if his appeal is without merit and he's appealing to the Court of Appeal, he may lose the benefit of any time served between the date on which he files his appeal and the date of the appeal hearing. That's Section 83W of the CPO. But it only applies to appeals to the Court of Appeal, not in the context of a magistracy appeal. Okay, so there is the risk, and you should warn your client of this, that he can lose the benefit of time served, but only if his appeal is without merit, right? So unmeritorious. But if he has good grounds of appeal, then he shouldn't be concerned about losing the benefit of time spent in custody. The Court on Appeal can quash the sentence, substitute another sentence within the jurisdiction of the original court. So your sentence could go up or it could go down, all right? Or it could dismiss the appeal and the sentence stands. So a couple of practicalities. Loss of time we've talked about applies to the Court of Appeal, not to a magistracy appeal to the CFI. This is really only imposed in exceptional circumstances, in other words, as a punitive effect. And as counsel, you should obviously never draft grounds of appeal that you do not feel are reasonably arguable. Fresh evidence could also be introduced on appeal, and you can get an extension of time to appeal to the Court of Appeal under Section 83Q as well as under Section 113MO, but not for an appeal by way of case stated under 105 or to a Section 104 review. Now, remember I said pigeonhole in your mind this reference to Section 83Z of the CPO as being excluded from the provisions of the CPO which apply to the district court. Remember I said that back on, what slide was it? Where was it? It was here, slide 31. We said where defendant is convicted in the district court, Section 83 provides that sections 80 to 83Y of the CPO apply, but there is a Section 83Z which does not apply. So this is why it is relevant now as we consider bail pending appeal. Okay, so if you are appealing, and in your exam, hopefully you'll be able to identify, as a general rule of thumb, I'm going to say at least 3 grounds of appeal against conviction. If you can't identify 3 grounds of appeal, something is seriously wrong. And if it's lack of preparation on your part, then that's on you. I can't help you, right? If you've identified, let's say, 3 grounds of appeal, have another look. There is usually at least, I'm going to say, 4 to 6 or maybe 7 grounds of appeal against conviction. Okay. So you are looking to write a lot in the exam. Okay. Not just a couple of grounds against conviction. Whether there's also grounds of appeal against sentence may or may not be relevant, right? But I would be looking for, as a bare minimum, 3 grounds of appeal against conviction, then looking to see if there's any grounds of appeal against sentence, then looking to see if there's any grounds of appeal against costs. Okay, so as a general rule of thumb, you've got less than that, something's wrong, go back, have another look. What have you missed? Okay. If you are advising good grounds of appeal, you need to consider the question of bail pending appeal. Now, in the final instructions in the exam, it will say something like, advise on actions that can be best taken to protect the defendant's interests. It doesn't say, advise the defendant on whether he should apply for bail pending appeal. Right? It says actions best taken to protect his interests. That includes advising him whether he should apply for bail pending appeal. Okay. It includes also maybe sometimes advising on if there's good grounds that he could lose loss of time because you've got no grounds of appeal, but that's rare. Okay. So if you are appealing a magistrate's court decision, magistrate can grant bail pending appeal to the CFI. He can also grant bail pending a review, or if you're appealing to the CFI, then the judge in the CFI can grant bail pending appeal. Okay. So there are 2 options for an appeal from the MC. Either the magistrate can grant bail pending appeal or the CFI judge can. However, under Section 83Z of the CPO, the Court of Appeal is the only court which can grant bail pending appeal from the district court or the CFI. That means that a district court judge, because remember, Section 83Z of the CPO is excluded from those provisions that are applicable in the district court. A district court judge cannot grant bail pending appeal to the Court of Appeal, nor can a CFI judge. Why? Because Section 83Z only gives that power to the Court of Appeal. Okay? So just remember, if it's an appeal from the district court, you have to get bail pending appeal from the Court of Appeal. And because if we think back to those early classes we had on bail, and I know you've moved on to mitigation, I know you're ready for the more challenging advocacy submissions, right? But let's think back to bail, because Once we've got criminal litigation procedure out the way, right? Your next nightmare is going to be criminal advocacy in early January. Okay. So let's think back to bail. Remember that we said that in general criminal cases, there is a presumption of entitlement to bail based on the presumption of innocence. Okay. Under sections 9D, 9G of the CPO, right? Presumption of entitlement to bail because of the presumption of innocence. However, once the defendant has been convicted, there is no longer that same presumption of innocence. So the test to get bail pending appeal is much higher. There is no presumption of entitlement to bail. The defendant needs to establish either that a substantial part of his sentence would have been served by the time of the appeal. Why? Because it's very short in nature, or that the appeal has substantial merit. And the test is in Lau Man Kin. Now let's consider the situation. Defendant is sentenced to 1 month imprisonment, right? Very good chance that he would have served all of that period of time before the Court of Appeal could hear his appeal, okay? Or even the CFI judge could hear his appeal, right? That doesn't necessarily mean that just because his sentence is short, he will definitely get bail pending appeal, okay? Because if he has no merit in his appeal at all, it would not make sense to grant him bail pending an unmeritorious appeal, because you would release him from custody on whatever conditions. He may abscond, and then he gets put back later once his appeal gets dismissed. So the overriding consideration is whether the appeal has substantial merit. And if there isn't substantial merit in your grounds of appeal, defendant won't get bail pending appeal. So if you've identified good grounds of appeal, then you should be advising on bail pending appeal for your client as well. Okay. Counsel's duty, very unethical to settle grounds of appeal that do not have a reasonable chance of success. You would likely have wasted costs imposed against you at trial. And by the way, a tip for your exams. I will think of where to put this in the slides after the lecture, and I will upload a slightly revised version of these slides because something occurred to me as I was going through grounds of appeal. In your exam, for whatever grounds of appeal that you identify, you must analyze whether those grounds of appeal are strong or good. That's possibility one. Strong, good, I'm going to take it. Those are pretty much the same thing, right? So are the grounds of each ground of appeal, is this a strong ground of appeal, a good ground of appeal? You have to make that analysis, okay? Or is it a reasonable ground of appeal? Is it something that may depend on what's revealed in the trial transcript, for example? Or is it a weak ground of appeal because the threshold to appeal flagrant incompetence maybe is really high? Or maybe it's a reasonable ground of appeal. It is a very high threshold to succeed, but you have very good reasons of counsel's incompetence, right? So I want you to make that analysis of whether the ground of appeal that you identify is strong or good, number one, two, reasonable, or three, weak. Okay. And when you get to SGS 8, you are going to be doing lots of drafting of grounds of appeal in memorandums and letters and all kinds of stuff. You'll have to make that same analysis as well. Okay. So remember that when you are drafting your memos, and I'll put that somewhere in the slides just so it's crystal clear. And if I was technologically savvy enough, I would put it in with ringing alarm bells and flashing lights just to make it even more clear for everybody. Okay, so what's the procedure? Now, in your exam, there will be 5 marks available for your discussion of the relevant procedures, okay? Including whether to, which court you are appealing to, right? So you've got to know your venue for trial, including whether you need leave or not, including the deadline to appeal. You have to say whether it's 14 days or 28 days, and you have to calculate the last date to appeal, including the particular form that you need to use to appeal, okay, and any procedural steps. So 5 marks available for the procedural elements. You have 32 marks in your written exam, so the other 27 marks will come from your discussion and analysis of the grounds of appeal, okay? 27 marks for the grounds of appeal, 5 marks for the procedure equals 32, plus 18 from your coursework, right? No worries, you're going to get 50 out of 50 for Crim Pro, Crim Lit, right? Because I'm not drafting the main paper, so we don't want any resets, okay? That's what we're aiming for. Um, all right, so how do we appeal then from the district court or CFI? So if you're appealing conviction only on a question of law, you don't need leave, you use Form 8. If you need leave to appeal, either because it's a question of fact or it's a mixed question of law or fact, or you're appealing sentence, you use Form 11. So for your purposes, usually grounds of appeal against conviction will be mixed questions of law or fact, so you'll be using Form 11. You file your initial grounds first, and then you perfect them later once you have references to the transcript. But the sanction could also be cost consequences if your appeal is unmeritorious. 28 days to appeal, and Section 83Q just says from the date of the conviction, order, verdict, or finding. But if sentences pass more than 7 days after the date of conviction, then the time to appeal conviction and sentence starts to run from the date on which sentence is passed. Okay, so let's say defendant is convicted on November the 1st. Okay, and sentence is passed on December the 10th. Okay, that means that the time to appeal, I'm just pausing for a second because I got a message that my connection was a bit unstable. So just to recap, I was saying he's convicted on November the 1st, but he's sentenced on November the 10th. That means the 28 days to appeal starts to run from November the 10th because sentence has passed more than 7 days after conviction. And remember that that could very commonly be the case where the court has adjourned sentencing to call for pre-sentencing reports. You can get an extension of time on that 28 days. But a critical question is, Section 83Q just refers to 28 days from the date of conviction. It doesn't say anything about clear days or anything like that. So what do we mean by from the date of conviction? The answer is we actually have to look at Section 71, subsection 1A and 1B of the IGCO. So let me stop sharing for a minute. Let's go back to the e-legislation site. Let's go to Cap 1, IGCO. If ever you're unsure about whether something has been defined somewhere, this is always a really good ordinance to look at. Okay, so Section 71 IGCO, let me share it with you now. This deals with the computation of time. So it says, in computing time for the purpose of any ordinance, a period of days from the happening of any event shall be deemed to be exclusive of the day on which the event happens. Okay, so remember Section 83Q, 28 days from the date of conviction or order. So in other words, when we calculate our 28-day period, we do not include the date of conviction or sentence. We start on the next day. Okay, so if he's convicted on November the 1st, sentenced on November the 10th, so November the 10th is the date from which we start, we don't include November the 10th as day one. We start counting on November 11th, which is day one, and then we count until the end of our 28 days. Okay, next complication. If the last day is a public holiday or a black rainstorm warning, the period shall include the following day. And this is why you need the calculator. Because if your 28-day period or your 14-day period under the MO ends on a public holiday, it's Christmas Day or December 26th, what we call Boxing Day. If it's a public holiday, you roll over to the next day, okay? And that's why you need the calendar to show you or to remind you what the public holidays are, okay? Because if your public holiday falls on December 25th or 26th, you're going to roll over. So let's say that your 28th day is December 25th. You're going to roll over to December 26th. Oh, also a public holiday. You're going to roll over to December 27th because the courts are closed on those days. Okay? Now, I also want you to take a look at subsection D, where an act is directed or allowed to be taken within any time not exceeding 6 days, no public holiday, etc., shall be reckoned. So, in other words, if your time period is 6 days or less, you do not count public holidays when you are calculating your period of time, right? So, let's say, hypothetically, doesn't apply for appeals, by the way, but let's say hypothetically you had 6 days to appeal, okay? And you were convicted on Tuesday, okay? Then we start counting on the Wednesday. So Wednesday's day one, Thursday is day two, Friday is day three. We don't count Saturday, Sunday because those are court holidays. So Monday would be day four, Tuesday would be day five, Wednesday would be day six. That would be our last day to appeal the following week. Okay. But that's only where the time period is 6 days or less. So for grounds of for appeals, we haven't looked at any time period which is 6 days or less. We've only looked at time periods of 7 days or more. Okay. So what it means is when you're calculating your 14 days or your 28 days or your 21 days, you count those days of Saturday, Sunday, public holidays in the middle of those 14, 28 days. You include those in your time calculation. Okay. So, it's all getting a bit tricky as we are right before a public holiday, right? But just to help, let me stop sharing here for a minute. Let's see. What can I bring up that might be helpful? Let's bring up a calendar. Mm. Give me a second while I find a calendar. Oh, asking me to pull up all kinds of annoying things. All right, hold on. I'm just going to do it very quickly on the screen here. Okay, so I've just gone on the right-hand side, I've just gone with April 2025, okay? So let's say that we have a 14-day period, okay? Let's say defendant is convicted. Let's do 28. It's easier. Right. So let's say defendant is convicted and sentenced. We'll make it really simple on 1st of April, April Fool's Day. More fool him. He was convicted and sentenced on the same day. So April 1 is the day. Okay. Now section 71(1) subsection A, we count the following day as day one. Okay. So this is day one, April 2nd. Day two, April 3rd. 4th, 5th, we include the Saturday and Sunday in our calculation of our 28-day period, right? So we start on April 2nd, we go 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28. Right? So 29th of April, the Tuesday, is our last date to appeal. Okay? Because in calculating our 28-day period, we include Saturday and Sundays. Now, if our 28-day period ended on a Saturday or Sunday, we would roll over to the next day. If April 29th was a public holiday, we would roll over to the next day. Okay? So just remember those provisions of section 71(1)(a), B, and D of the IGCO when it comes to calculating the time periods to appeal. Okay? Because in the exam, you must come up with the actual deadline. It's a bit of mental gymnastics, I know, and it's a lot to take on at this stage of the night, but read the provisions carefully. If you missed anything, maybe go back to the recording, rewind it, and go back over it again. Okay. But bring in the calendar November, December, January, November, December 2025, January 2026. Start counting for a DC CFI appeal on the day after the event happens. Okay. Use the weekends and public holidays in your calculation of the 28-day period, but just remember, if the last day is a public holiday, roll over to the next. Okay, I saw there was a question. Let me see. If the 28th day is on a public holiday, Saturday or Sunday, you just roll over to the next Monday or to the nearest working day. It's to the next working day that the court's open. But if you think about it logically, because the 28th day is an even number, right? If you would never have the defendant convicted and sentenced on a Sunday, for example, right? So your last day to appeal, the 28th day or the 14th day, is never going to be a Sunday, right? It'd have to be a public holiday, for example. Okay. All right. Appeals to the Court of Final Appeal. Now, I'm just going to deal with this very briefly because, as I said at the start, we've never had an exam fact pattern that deals with appeals to the CFA, nor will you this year. So we're taking that off the table. I'm taking very little off the table, but I'm taking this off the table for you. Why not? Because in practice, you would never be instructed to appeal to the CFA as leading counsel until you have at least 5 years experience and usually just senior counsel, right? But what can be appealed? Final decisions of the CA, final decisions of the CFI, like if the CFI judge has heard a magistracy appeal, then you can appeal to the CFA, but you need leave. And you have to establish either a point of law of great and general importance or substantial and grave injustice has been done. So very limited scope for the CFA to interfere on an appeal because it is not a second court of appeal. It will only intervene in serious cases. And then David talked you through appealing against cost orders and cost refusals as well. Basically, you use the existing provisions of the Magistrates Ordinance as well as the Costs in Criminal Cases Ordinance to appeal cost orders and refusals. So under Section 19 of the CCCO, which you should read if you haven't already done it, read the entire ordinance, it's very short. You can appeal a cost order within 21 days of it by notice of motion, right? So if in the exam you are asked whether there are grounds of appeal, right? And you will be, and you see that a costs order was imposed, right? Then you may wish to consider whether the defendant has good grounds to appeal the costs order. If so, the procedure is set out there in the second bullet point, okay? But you can only appeal a costs order or a refusal if there is a statutory basis to do so. And there is no statutory right of appeal against a refusal to order costs to an acquitted defendant in the district court, right? David told you that the general principle is that an acquitted defendant gets his costs, right? Unless he did something to bring suspicion upon himself. But if he's acquitted in the district court and he applies for his costs and the district court judge refuses those costs, you cannot appeal that cost refusal. You can only appeal a costs order in the district court, right? So remember, there's two sides to costs, right? So if the defendant is convicted, right, then he may be ordered to pay the prosecution's costs as well as his costs, okay? So he has to bear both sides' costs. He could appeal that costs order in the district court. But if he's acquitted and he's refused his costs, so the district court judge refuses to order the prosecution to pay his costs, he has to bear his own costs, he cannot appeal that refusal because there's no statutory basis. He has to apply to judicially review that decision, that refusal. And there's a high threshold, okay? So just remember that for an acquitted defendant who is refused costs, okay? But he can appeal a costs order, all right? Okay, so 61 of you have survived to the bitter end. Are there any questions? For the brief to counsel, what is the exact instruction to counsel? Can you clarify what you mean by the exact instruction? Is it not set out for you in your activity plan? What do you mean by what's the nature of the exact instruction? Are we asking him to advise on the merits of the evidence? Okay, let's go back to, if in doubt, guys, always go back to your instructions, okay? So let me share the screen, okay? This is your activity plan for SGS4, right? Okay, top of page 4. At the SGS, you will construct a draft brief to counsel in Willie Marr to advise on the merits of the evidence. Okay? You will individually draft the brief to counsel. Set out the nature of the instructions, right? So, yes, that is what you are being asked to do, to draft a brief to counsel to advise on the merits of the evidence, okay? Apologies if your tutors didn't make that clear in the session. Okay, so it's not a brief to appear at trial. It's not a brief to appear at the mention hearing. It's not a brief to advise on sentence. You're advising on the merits of the evidence, okay? But as part of that, you want to pose specific questions for counsel to answer, right? So the indecent assault, right? What is it that you want counsel to answer when it comes to whether the act was indecent, whether the words said are evidence of indecent intent. Okay, those are specific questions you might have for counsel. You want counsel to advise on whether Willie's defense, right, of professional interest, on the merits of that defense. Okay. And then you also want counsel to advise on whether reaching out to the prosecution to negotiate an amended charge of common assault is a good strategy because Willie is willing to PG to that. Okay. All right. So is that clear now? Okay. Anything else you want to ask? If the defendant is legally aided and no cost order against him, will the prosecution still not be happy and proceed to appeal on costs? The answer is that if he's legally aided, then the cost order in any event would be very small because it would only be up to the amount of his contribution. All right. So I think in that case, the cost of appealing would probably outweigh the actual cost order that would be received in that event. Um, okay. In your SGS, you didn't get to attempt the draft. Okay. Why was that? Was that because you ran out of time? Or was that just because your tutor didn't cover it with you? Because it was definitely in the tutor's notes, and actually in other groups, they were split up into groups. I mean, at the end of the day, you can discuss it amongst yourselves anyway, right? You don't need to have time set aside in the SGS. So in your groups, even if you didn't do that in the session, you can still consider some of these issues um, with your group mates, right? So, hey, what do you think we should be asking council to advise on? What do you think are the key facts in Willie's personal background that you want to draw to his attention, council's attention, right? Because think about it, does it really matter where Willie lives or who he lives with? What are the key facts in his personal background that you want to draw to council's attention? Okay. We need to state our previous advice. Are we going to ask council to confirm our view? Yeah. So the way that you usually do it is you don't say in the brief, in my opinion, the defendant has no defense, right? What you would say is you use the language in the views of those instructing or in the opinion of instructing solicitors. So you put it in the third party and then you state your opinion. And then you may say something like, does counsel consider this to be a viable defense? Or does counsel agree with this approach? Or does counsel wish to adopt an alternative strategy, right? So don't just be my opinion, full stop, right? Otherwise, there's no point for your brief to counsel. Okay, you must be asking counsel to give the advice to confirm that your view is correct. Okay. And you may wish to refer counsel to any uh, cases that they may be unfamiliar with, right? So you don't need to refer to the Queen and George, the Queen and Court, etc. But you may wish to refer to Hong Kong cases that they may not be so familiar with, like the Wan Ho Yeung on the indecent assault in the library. Okay? All right, guys. So have a lovely day tomorrow. Thank you for staying. And I look forward to hopefully seeing you in person soon. Okay, we'll leave it there for tonight. If you do have questions on the brief to council, please post them on the discussion forum. Do not email me individually, okay? Because I can't answer. It's an assessed exercise. We have to keep it fair for everybody, okay? All right, guys. See you soon. Bye. Oh, thank you for your best wishes. Unfortunately, recovery is a little bit slower than I would like, but there we go. All right. See you soon. Bye.